Dr. Babasaheb Ambedkar Open University.
Okay, friend. Again, warm welcome into the Chaitanya studio of Dr. Babasaheb Ambedkar Open University. In previous session, we discussed regarding some important section under the Indian IT Act. Now, then after we also discussed regarding the chain of custody and the importance of handling digital evidences. In the same line, I would like to continue our discussion regarding the intellectual property in a cyber world. So first of all, what is mean by intellectual, or what is which kind of property we can categorize as an intellectual property? Because as we know, we are aware about the tangible property, the property which we can see, which we can touch. So these are the physical property, but certain kind of properties can be categorized as intellectual properties. Intellectual properties, that means the properties which we cannot touch, or they are not physically in existence, but it's a result of some intellectual effort, result of some intellectual brains. It's we can say creative work, or a pure essence of intellectual creativity. All these kind of work can be categorized as intellectual properties, and for these kind of properties, the same government has provided specific kind of infrastructure to protect the creators of the property, and to keep or to maintain, to protect the benefits of the property creator. So we can say intellectual property are the legal rights that cover the privileges given to individuals who are the owner and investor of a work and have created something with their intellectual creativity. The creator, inventor gets exclusive rights against any misuse or use of work without his her prior information. So for example, the patent, or we can say the song lyrics of famous Bollywood music composer, tunes of Bollywood music composer, or lyrics of famous poet, or a book, means novel chapter of any author. Now if as we know, this is not a random effort. These are the essence of some creative intellectual effort, because any investor, those who invented, or those who derived some important drug formula which can cure the particular disease. We can say recently the COVID vaccine. So to derive the formula for the COVID vaccine is not an overnight effort. It need lots of intellectual investment in terms of lots of brainstorming, lots of experimental studies of the different drugs or different drug formulas. So the COVID vaccine is we can say the COVID vaccine is an outcome of a brilliant brain's intellectual effort. Now, once the scientists, those who found the formula for the COVID vaccine, needs to be protected because they also expect certain kind of financial benefit, as well as they also expect social recognition, because ultimately at we know they, in other words we can say, they had extended their intelligence for the society also. So as a reward we need to provide, or society need to provide their financial benefits, and they need to provide the social recognition also. So these kind of matters can be dealt with the Intellectual Property Right Act. And the important things need to be protected are patents. Patent, that means simply just we discuss regarding the COVID vaccine patent. Then after the trademark, geographical indication, layout design of the integrated circuits, trade secret, copyright, industrial design. So for example, patent are nothing but the exclusive rights which are reserved for the inventor or for the researcher. The trademark are for the business houses. That means we can say the trademark for the logo also. You cannot use the logo of some popular organization or popular business, well-known business houses, for your own benefit or for your own business, because the trademark policy violation is there. Then after geographical indication, you are familiar with the GI tag or geographical indication, because as for example, if we know the turmeric and the Ayurveda, so Ayurveda is the human treatment therapy in India, and which is in existence from large, because it's we can say it's our ancient, or it's our heritage. Now if someone is claiming that the turmeric will cure this turmeric is the proven remedy for this kind of illness, or the turmeric products will cure this kind of diseases, and if he or she wants, he or she is claiming for the patent on this kind of remedy, at that time the intellectual property right is also provides the geographical indication, and it provides the legal shield against this kind of illegitimate claim. Now then after the layout design of the industrial circuits, layout, that means for example, if Intel is come up with the i10 processor or i11 processor with the 10th generation technology, at that time the most important thing for the Intel are they need to keep secret, or they need to maintain the layout design of their ICs and their board design. So the intellectual property right covers the privileges in that case for the on behalf of the Intel corporation. Then after trade secret, that means so many organizations, those who are in a business since long period, have prepared their route plan, their we can say their delivery route plan, or their trade secret in that terms of customer behavior pattern for the particular product, or customer buying pattern for the particular product. So all these are the trade secret for the any organization, and these kind of secrets have been derived by the long time observations and experimental studies based on these observations. Now then, after, if any organization who steals the information and use for its own benefit or its own interest, at that time the intellectual property right provides the legal shield or legal cover to maintain the benefit or to keep the interest of original organization. Then after, industrial design, that means so many industrial designs, like particular organization, or for example any famous business house like Reliance Industries has set up its refinery on a large scale. Now they have to provide their plant design for the insurance purpose, for the for the insurance purpose to the insurer organization or insurance house, insurance companies. They need to provide their plant design to some government agencies. They need to submit their design to some government agencies also. So at that time, it is common, or we can say it is natural, that some rival organization may get this design by using some unethical practices, and then after they might use all this design for their own plant setup. But in that case, intellectual property rights are provide a legal cover, and they by using the intellectual property rights, Reliance can hold privileges in this kind of design. So these kind of protections are available under the intellectual property rights. So friend, copyright, we can say copyright is a right given by the law to the creator of literally dramatic, musical and artistic works, the producers of cinematograph, films and sound recording, to do or authorize the doing of certain acts with regard to their creation. So copyright is we can say the right for intellectual creation. For example, any producer of a movie can have a copyright for his or her creation. Then after, we can say author or the publisher of the book, publisher organization of the book can have right and these right provide certain kind of authority to the producer or to the copyright owner to use this content for their own benefit or their own interest. And it is very common, like if we are watching movie, then we see or we learn to like a message that all the copyrights are reserved. Or so what is the copyright? Copyright is nothing but it's a right. That means the content which you are seeing or you are watching is reserved, and you can rightful or you are authorized to watch only, but later on you cannot reproduce this kind of content for any purpose, either monetary purpose or for any entertainment related purpose. The most important thing, copyrights are, it is a kind of protection against the unauthorized use or misuse of work, but for the limited duration. So simply there are various categories according to the law, like for the music, for the text, means for the written content, for the video, for each and every category the well defined the duration has been defined, and during those period no one can use this kind of content without the written permission of copyright owner. So this is the copyright. Generally the rights include the rights of authorship, reproduction, distribution, communication to the public, broadcasting, adoption and transmission. So as we discussed, these rights reserve the copyrights provides the authority to the owner regarding the authorship. So without his written concept, without author's written concept, no one can reproduce the similar kind of content, no one can distribute the same content. Now in a cyber legal aspect, the piracy is a main threat against the copyright, because as we know, as we see nowadays, the piracy is the burning issue for the organization, because of course due to the privacy they have to suffer from a huge financial loss. For example, for any movie, the movie content is uploaded on the portal or on a website. Now the restriction or the limitation for the law is that because the particular kind of content is uploaded for particular organization which is hosted on the another country's server, in and the geographically limitation, because the Indian IT Act is applicable in the Indian geographical boundaries only. So in that case, someone is uploading the content on a website which is hosted outside of the India, then after what, with the help of Telegram or with the help of any social media, the download link has been circulated among the community, and the public or the people user download this kind of content through their mobile phone or laptop, means by using digital gadget. So this is the classic example of the copyright violation, and during this kind of violation, Indian film industry is facing big challenges in terms of financial loss. The same thing, the copyright violation, like, because nowadays the handheld mobile phones are very common, each and every person is having mobile phone. So for example, if any author who has written the book and any publisher house who has published the particular book, so they are expecting to sell the book, and they are expecting the profit from the selling of book. But generally what happens, the people is having the mobile phone, and if or she likes certain content in a book or a particular page on a book, then what they do, simply they are capturing the pictures through the mobile camera, and later on they can use or they can read this kind of content. So again, this is the copyright violation case. So in India, in the Indian context, in India, copyright is governed by the Copyright Act 1957. So it is since 1957, the copyright rules 1958, the International Copyright Order 1999. The Copyright Act provides the basic law so far as copyrights are concerned. The copyright rules contain the rules and regulation as well as various procedure, and the International Copyright Order extends the copyright protection to work nationals of specified foreign country. So even if you are capturing the pages of a particular book which is published outside of India, again the book which is published outside of the India, although the geographical boundaries are not connected or jurisdictional restriction, Indian jurisdictional restrictions are not applied or not applicable, you are liable for the execution under the Indian IT Act. So this is the copyright infringement. And same thing, you cannot download the Hollywood movie in India, because of course the movie producer is having the copyright for the movie, and the jurisdiction applied for these rights are USA, and it is completely different or completely irrelevant in the Indian jurisdiction. But according to the International Copyright Order, it is the copyright infringement. Now we can say the copyright is a bundle of rights, and this bundle can be broadly classified into two categories: economic rights and moral rights. Now what is the economical right? Economical rights are so called because they apply as a rule that within the limitations set by the copyright law. We can say the copyright are so called because they imply as a rule that within the limitation set by the copyright law, the owner of the copyright may make all public use of the work conditional on payment of the remuneration. So again, the financial means the remuneration is discussed, and they mainly because the economic rights. So the copyright protects the financial interest or financial benefit of the original producer or the copyright owner. So which kind of work is permissible with the consent of owner are the right of reproduction, right to issue copies of a work, right to public performance, right to communication to the public, adoption right, and translation right. So now my simple question is that we all know about the DJ party. Now we have studied the copyright, and we have also studied the intellectual property related things. So my simple question to you is that, is it legal or not? The DJ parties are legal or not? Is there any violation of copyright law or not? So this is my simple question, my dear friends. According to the law, we cannot arrange or we cannot enjoy the DJ parties. Right now they are very common. Simply the common thing, we are having the mobile phones. In a mobile phones we are having so many songs, and the sources of song, we have copied the songs from our friend's mobile, or we are downloading the songs from the uh, popular sites, like which on which the content is available freely, but it is illegal. We cannot play the songs until unless we have purchased those songs, or we have paid those songs, or in other words, we can say there are so many another examples, like for the popular folk songs, or popular we can say some video contents which are available on YouTube, and we to view the video on YouTube is a completely different thing than the to download the YouTube video and save those video in our laptop or in our mobile, and to watch later on these video. To watch the video on a YouTube online is a completely legal or is a permissible, but if we are downloading these video in our laptop and then we are watching all those video for later on, or for a future, then it is not permissible. It is the complete violation of the copyright policy. So friend, in this session we discuss regarding the intellectual property right. Intellectual property right, that means the properties which are not tangible, but these are the brainchild of some intellectual efforts, either group or individual effort, and as a result of this kind of effort, they have proposed some model, they have proposed some lyrics, or this kind of work, intellectual work, are protected under the intellectual property rights. And among the intellectual property rights, the copyright is the main concern. So we have also discussed the copyright. Copyright is nothing but the guideline or the rule, a bundle of rule which provides the protection for the original creator or the copyright owner. Okay friend, thank you very much. See you in the next lecture. Thank you.
स्वाध्यायः